Good afternoon and welcome to yet another episode of Diary of a Lawyer. And in this case, we are looking further and deeper into the case of Gonzalez versus Google, which is a petition that was filed in the US Supreme Court. And it's, in legal terms, it's a petition for a writ of certiorari, which is essentially asking the court to quash a previous decision or to review or override and take an act appropriately, but essentially a review of a decision made by a statutory or executive body. And the question presented, according to the papers filed in the Supreme Court, which are on the Supreme Court website, the question presented is section 203 brackets C subsection 1 of the Communications Decency Act, which immunizes an interactive quote-unquote computer service such as, for example, YouTube, Google, Facebook, and Twitter for publishing information that is provided by another information provider. And the most recent of the Court of Appeals decision is related to section 230 subsection 1, as mentioned above. And prior to that, the 5 courts of appeal judges had concluded that section 20 subsection 1, the one we're discussing, apparently creates such an immunity, and 3 court of appeals judges have also rejected such immunity, and 1 appellate judge has concluded only that the circuit precedent precludes, according to the information in the case, precludes liability for such recommendation. And the legal question presented, again I'm referring to verbatim here, is that whether section 230 subsection C1 immunizes interactive computer services when they make targeted recommendations of information provided by another information content provider, or only limit the liability of interactive computer services when they engage in traditional editorial functions, such as, according to the information brackets, deciding whether to display or withdraw with regard to such information. And as I've already mentioned, the parties to the petitions were Reynald Gonzalez, the estate of the deceased Norman Gonzalez, Beatrice Gonzalez, individually, and another mutual of the estate of Nahogomi Gonzalez, Jose Hernandez, Ray Gonzalez, and Paul Gonzalez, which I'm assuming some of the family members listed for the Gonzalez, and the respondent, of course, is Google LLC. They did mention other directly related cases, such as Gonzalez v. Google, number 1816700 Circuit of Appeals judgment, which was entered on, according to the information here, on the 11th of January 2022. And there's also another case of the same parties, listed for 16CV03282 GMR, and that's a reference, in the Northern District of California, and the judgment was entered on the 31st of August 2019. Now, they did list some opinions below, but the background is that the Gonzalez was killed in an apparent terrorist attack in Paris, and that triggered the basis of this lawsuit as to whether the social media and the respective social media have a duty to minimize the level of information that part individuals may be exposed to, which then may um, allow them to get sort of radicalized and then commit such acts, which may lead to the innocent um, losses of life, such as in this case, tragically. They mention an opinion, and the opinion referred to below, according to the Supreme Court papers, is the June 2021, which is the opinion of the Court of Appeals, which reported to which set out on page 169 of the appendix, and they refer to the 23rd October decision of the District Court, and also the January 22nd order denying rehearing quote unquote en banc, which is set out on page 260 to 262 of this appendix. And the jurisdiction of the Court of Appeal was entered on the 22nd of June 2021, and a timely petition for rehearing was denied on the January 3rd of 2022, and this refers to the confirmation that this court has jurisdiction pursuant to 28 USC. I'm assuming that refers to the US Supreme Court, and the also refer that the district court has jurisdiction. They've already made reference to the statutory provisions involved, which was Section 230 of the Communication Decency Act in 1966, and those were sort of the arguments. Those are the key sort of question, and the actual legal documents and the statement of the case are very detailed and would require pages and pages and hours to go through. But I think the central theme is that whether the social media can be essentially held liable for acts committed by third parties on the basis of the information that they put out on their various platforms. Now, the decision of the Supreme Court in this case will undoubtedly have a huge impact on social media providers the world over, in terms of the content they put out, in terms of the level of control they have, the editorial control, the level of access they allow, and ultimately potentially either legal and criminal, or potential criminal liability. Obviously, every case is different, and it depends on the specific circumstances of the case. But I think the overarching point is the decision will be instrumental and pivotal in terms of the ongoing conversation that we, the public and the media and the politicians all over the world have been having as to what level of responsibility do social media companies, huge conglomerates who sprawl the world over, what level of liability, control, power they should have, and responsibility over the level of radicalization or harm that may follow, whether it's psychological or physical, as a result of the content that they put or hold up on their platforms. And that is really sort of the central question. And the conclusion, again, for the writ that was filed of Certiorari was, to review the judgment of the Court of Appeals of the Ninth Circuit. At the time of recording, I'm not aware of any published formal decisions, and we shall keep you posted. But this is one of those key cases that are transformational and may impact just the whole of the internet, which is central to many of our lives, whether it's having this sort of discussion and recording, or travel, banking, accommodation, finances, day-to-day transactions in our personal lives. And so this is really a critical decision. And so that is really in a nutshell. I mean, it's the legal arguments are complex and long, and I don't think it's the right place and forum to go into those specific details, and it will take a lot of time. But we will update when the outcome and the verdict is read out by the Supreme Court or published, hopefully sooner rather than later. And thank you. Have a good weekend. We'll speak again. Thank you. Over and out. Bye.